on appeal in the matter of
Yes.
Yes, good morning, my lady and my lord. I appear on behalf of the appellant children through their guardian, X and Y,
Yes.
I shall refer to the children as. Mr Barnes, on my right, appears on behalf of the BBC.
Good.
My learned friend, Mr Patterson, today, a new face, I should say. Miss Strong is not here for the local authority, but we welcome him. He is representing the local authority. And, of course, Mr Lafazanides, who is representing the carer in this case.
Yes.
My lady, this started life as permission to appeal application from a decision of the judge, Mrs Justice Lieven, dated the 6th of December of last year. She gave judgment on the 14th of January. That is a judgment you will find at page 41 of your core bundle. And the order that was born out of that decision is in effect a transparency order which was due to be published on the 17th of January, but in fact this court, granted a stay. That order permitted the disclosure of various documents and gave permission to the BBC to report. The overarching aim of the appeal was to seek that the order be set aside and the appeal allowed on the basis of it, the decision that is, being wrong. That is the basis upon which the case has travelled thus far, and it came before Lord Justice Warby and Lady Justice King on the 17th of March as a permission to appeal hearing. Prior to that, at the behest, in fact, of the court, for us to contemplate a question that was posed, the grounds of appeal that had previously been filed were amended to include a ground 4, as it was then, and I shall return to that, but effectively that ground 4 today is ground 1 of the appeal, and the grounds of appeal I will come to in a moment are at page 23 of your bundle. Just in the terms of this appeal, it was listed for 2 days on the 1st and 2nd of July. There have been various directions from the court, and on the 3rd of June, an email was received from the BBC saying that they would in fact consent to the appeal on ground 3.
Yes.
And ground 3 embodies and embraces, as you know, the impact of reporting on the particular children in this case, not attaching sufficient weight to that, on the effect that reporting had already had and would have in the future.
Yes.
I, of course, summarise that, my
Well,
lady.
we're obviously very familiar with both the substantive and the procedural background, and we know why we're here today.
I'm grateful.
And it's very helpful. Yes, so the BBC states its position. It is prepared to agree to the appeal being allowed on ground 3, and since then we have indicated that we would wish to hear argument if necessary, if it's still a live issue, as to whether or not the appeal should be allowed on ground 1, because if of course the DRING principles are not engaged, then the balancing exercise doesn't fall to be carried out. So we want to take it in a logical order. Your position is that ground 1 is good.
Ground 1 is good, and as you have said, the domino effect, if that were to be the ground upon which it was allowed, would be to mean that grounds 2 and 3 would fall away.
And as I understand the position for the local authority and for the second carer, or the carer, their position is also that ground 1 is good. Is that correct?
Yes, ma'am.
Mr. Barnes, thank you for coming along. We saw and have read your submissions for the permission hearing on ground 1. So we see how you put it there. And is that the position that you maintain? And so do we need to hear argument on ground 1?
Well, my lady, I hope in the circumstances, and obviously understanding the court's reasoning both for hearing the matter, because part of the disposal of the appeal involves the making of a reporting restriction, which I well understand the court may wish to consider that as well. But the indication given yesterday that ground 1 may be an issue for consideration. The court obviously has the submissions that the BBC made in advance of the commission hearing.
Yes.
But on the basis of the session in relation to ground 3, I don't seek to advance a particular case in relation to the broader grounds that the court wished to consider. It obviously falls within the court's discretion to consider the basis on which it seeks to, or which it considers appropriate to allow the appeal, and obviously that allows for consideration of grounds 1 and 2 as well, the basis of the concession the BBC make, which we say is sufficient to dispose of the appeal, is aligned to ground 3, and you've seen the analysis that both one of them, as Bretton and I, put before the court. But ultimately, the court will have to weigh in a conventional manner the degree to which the importance of the issue in ground 1 is one that justifies the court proceeding in circumstances where, as between the parties, there isn't necessarily a disagreement.
Yes, well, we do think it's sufficiently important. I mean, the limits, the proper limits of the very important transparency and open justice principle, to which we all subscribe, is a matter of, I think, of general interest.
Yes.
So I think we do want to address ground 1, and we have looked and been much assisted by your earlier note, which we have at pages 118 and 119. And if that remains your position, and or in any event, it would be very helpful to hear from you whether there's anything you'd like to add or subtract from those written submissions. I mean, obviously your client has an interest in these matters, and so we would be very grateful if there is anything you'd like to add. The short position against you is that whilst the private fostering arrangements may have been background, they may even have been in evidence, the actual operation of the arrangement was entirely out with the court and the court workings and procedures, and one can understand readily why the application was made in the first place, because the facts were not clear. It wasn't entirely clear whether or not the local authority had blessed the private fostering arrangement under some sort of court-initiated or under the auspices of court procedures. But as it turns out, they were entirely independent of anything to do with the workings of the courts and tribunals. And in those circumstances, at the moment, speaking entirely for myself, I find it difficult to see how the Dring principles were engaged on the facts. So that's the point we're interested in, because it's important that the limits are properly identified.
Yes, and my lady, obviously the particular context of this case and the background with which obviously the court is familiar and has the benefit, as to the BBC, of the documents that were disclosed following my lady and my lord's consideration of the matter on permission to allow some of those documents to be received under the terms of.
And what we would want, we would, I think, have in mind would being able to just be as helpful as possible to everybody. Nobody underestimates the importance and the progress that's actually been made in the family courts in this area. At the same time, just keen to, as it were, assist the parties to know how to go about these sorts of disclosure issues. I mean, there would, I think, would it be right that there would be a route under the Freedom of Information Act against the local authority, public body, for example?
Well, I don't think the issue, albeit I know that my Lord Justice Warby raised the question at the commission stage, I don't think in any of the arguments that are before the court from the other parties, obviously BBC not having this kind of an argument, that the Freedom of Information Act route has not been considered, and I'm not sure the degree to which, in circumstances of the case, that would be a likely viable route.
No.
Anyway, the question, I'm not sure I can necessarily advance the matter further than the material that we've provided in writing, which obviously we're.
But do you still submit? Is it your client's position still that the open justice principles were engaged in relation to what I'm going to call the private fostering arrangement?
I don't seek to advance a position in relation to ground 1 at the moment.
Right.
In light of the concession on ground 3, it's not a matter that has been considered fully, but I accept entirely that it's a matter for the court to consider whether there are issues, and obviously I
okay, but just so you understand, Mr. Barnes, that this is your client's opportunity to address ground 1, because as I've indicated and as we have indicated throughout, we do think it's something we need to grapple with. So our intention at the moment is to do just that, and whether it's necessary for the disposal of the appeal or not from your perspective, just putting my cards on the table, that is our current intention. So if you'd like to take some instructions or say anything further on ground 1, we're very happy to give you 10, 15 minutes to do that.
I'd be very grateful to clarify.
Would you agree with that?
Yeah, I think
He's happy with that. Yes.
Thank you.
Thank you. Is there anything else from anybody else? But there is this. She says, a bit like Columbo.
Who I remember.
Can we just flag up some early concerns and thoughts on the draft order, whatever the outcome on ground one, so you can use the time, I hope, fruitfully. In the narrative, under the heading upon the BBC confirming in writing, we would go on to add, and upon the court waiving the requirement on the BBC to serve a skeleton argument, add in upon hearing counsel for, etc., in the recital, and then take out by consent, because I think there are some items that have not been formally agreed to. We propose, provisionally, subject to representations from everyone, so very provisionally. One, the first paragraph should be that the appeal be allowed. Two, that the order of Mrs Justice Lieven dated the 20th of January 2025 be set aside. Save that. We think that her judgment should be published after anonymisation to be agreed with the parties. So, save that. Her judgment should be published after anonymisation to prevent identification of the children, to be carried out by the second respondent and then agreed between the parties. Vacation of today's hearing, obviously that paragraph, that sentence goes, as does the non-publication sentence. You provide for the final anonymity and reporting restriction order to be made in terms mirroring the interim order. Well, we have no difficulty with that order, but your separate order is, with the greatest of respect, a mess and does not mirror the interim order. So please could you sort that out? And the rest of it, I think, is unaltered. So those are, as I say, very much our provisional thoughts and indications on the draft order, which you could perhaps spare Mr Barnes, who's going to be busy doing other things for the next 10 to 15 minutes, but perhaps you could work out whether or not those ideas and thoughts are acceptable to you. Mr Barnes, if you need a little bit more time after that, let me know. But at the moment, we'll come back into court at, well, I think the heat is doing something to my computer's clock, my watch, my wrist clock, and the clock in the building. But let's say 11 o'clock.
Thank you.
All right. Thank you very much indeed.
All right.
Please remind the board that the live stream is still on.
Thank you. Okay, I think the live stream is on, so I'll just go outside.
Yeah. Has he tried?
Is it the button? I'm good. And then you work first.
Has he tried? No, it's good he tried. So the effort's there. Well, I'm the referee. It's not winning. It's to take part of the council. So that was always when I lost every single thing. I think you'll find. This is very much I'm conscious of my honestly, on the flight back, did I tell you I didn't tell you about this? Did I mention it?
Yeah, you did. Well, you didn't until after you did.
So on my flight from London to Singapore, so she must have been about 2. She was fine for Manchester. Decided I've done all this good work and we'll chuck it out the window. So she decided to just give it a brush.
Where was she sat next to you?
No, so I was in the middle 3.
Okay.
The seat next, so I was on an aisle. Seat next to me was empty, touch, and then there was, and then there was her dad,
Okay.
and then his wife, the mother of the kids, and 2 kids were sat in the window.
Fine. Okay.
So she was a fair way, but you know, like that. And when you're in a floating tin can, floating fart tube. So last year, got chatting to me. Oh yeah, where are you going? Oh, don't do Kuala Lumpur. I can't compare it a couple of years. So, is she going to remember age 2, that family trip? I think the answer is no. So, therefore, that's the question. Why bring her? Why bring her? I think we can. That's what grandparents are for. So, because honestly, a couple of times I thought to myself, I met my intrusive thoughts wing. Would it matter if I popped the side door and just swung out? I said, don't worry about it, I'll shut it, and then.
I think Farah's just was she shouting?
Just doing that awful demonic scream.
Oh, that one.
Yeah.
Every time there's someone.
She was kicking, and I was just thinking, you know, if she did that on my chair.
I once was the gay kid on the fact that he was
Did you say he was fine?
He was adorable. No, he was really cute. But he was kicking and
No, the sympathy isn't necessary.
he was being really mean. And then just went back and did kick me. I was ready to break him. It was consistent for like a 3 hour. I feel like
You'll be watching the Women's Euros, seeing as Portugal are there. I think Portugal are there, aren't they?
yeah, they are, but they're not very good.
Yeah, no, they're not great.
Like, it would be amazing
I wouldn't
if
call
they
them.
get out
I wouldn't call them a powerhouse. Let's put it that way.
Yeah.
I mean, to be honest, the way England are playing, look out.
Really?
They've got the same. They've got the same problem. England's winning as England's men did in 2006. England's men in 2006 had Rooney, Gerrard, Lampard, Ferdinand, Terry, Cole. Objectively, the best team of the tournament. Or subjectively, the best team of the tournament.
Yeah.
You have 11 brilliant Beckham as well.
Yeah,
you have 11 brilliant football players who can't play together. England women have some fantastic footballers. Lauren James, Aggie Jones, Millie Wright Ashby, Willie Williams, Kira Walsh, Georgia Stanway, and they just go. Well, they seem to do it in 2020. When did it? 2022, when they won the Euros. But then in the warm up, they had a really rough qualifying campaign.
Is it the same team that won the?
And got Jim Scott. It was great.
Just not joking. Stick them all in the house, make them into
Yeah. Castle with 3 lines.
Yeah, exactly.
I've got a question.
No.
Hasn't it? Oh, yeah.
Oh, did you?
Yeah, you
Did I
told
tell
me. Yeah, you told me.
Yeah, no, he hasn't. No.
But I
And
thought
I'm
it
not
was always-
expecting.
Oh no, I was going to say.
Yeah, you were like, he probably will.
Probably will. It's like that.
Because I
God
just
knows
think
try.
it's a pride thing, though, isn't it? Really.
Not necessarily for him.
Yeah.
For you, yeah, for you.
Yeah, maybe. But I just don't. I don't think he's the kind of character that would try it.
I went home last weekend,
Oh, yeah.
and my mum said, "Nella's got anything." My stepdad was like, "How do you know this?" She was like, "Oh, I still follow her on Instagram." It was like, "That's weird." It's like, okay.
I think my mum and my ex's mum still follow each other. But then they really took advice for like they really got us so fun. But and I wouldn't want my mum to be like, oh hey, so and so has like I don't care, it's none of my business anymore. But you're still friends with them.
We haven't spoken once.
Oh, have you not?
I wouldn't say that's because we. If she texts me tomorrow, I would have no issue.
Yeah,
having
yeah,
a
but
conversation.
you don't.
No, it was a very clean break.
Oh,
Exceptionally clean break.
I mean, I think it's but well, you did.
You should have got my email by the way.
Yeah, I phoned him.
Oh, did you? Sorry, no, I didn't. Yeah, so reading between.
Was it enemy territory?
Mum about this case, she said, "Oh, we're expecting a judgment from the."
My understanding. No. But they have part of what they're going to buy it because they specify leave.
Well, and also. Did you see the case of Finley Bowden? It was in front of he was accused of murder on Christmas Day. And it back to Andrew and I worked together and he said, "Can you have a salary? I'm really in front of him." But she said, "This is what she said."
It's like really, isn't it? But why has it? Absolutely gorgeous. This is how I know I'm old because
I have to say, the stuff we got away with in 2008, when I say we, I mean me, Did you have wide frame?
Didn't get glasses until
Yeah, so it's the best way. Not too much, but just enough.
yeah,
Just enough to never get in trouble.
exactly.
Yeah.
Yeah.
Don't need to be in class really. My parents are Callum was clearly very smart, just needs to try that.
Yeah, absolutely.
Callum's clearly smart. He just needs to stop talking. That's basically the gist.
Guess that.
No, my dad looked as well. They told us the last time. I had a group of friends, but I wasn't.
Oh no, I'm going to have to go to probably.
Yeah, obviously.
George's. These chairs are so hard.
But it's not
You didn't. Oh, yeah, you got advice like that.
I can see your screen on YouTube.
Typical Windows share.
Apparently I might say that.
Well, I think
I've got a white tie shirt. I haven't got tables. No matches.
Bianca from the Society of Design. Oh, so if you let me know.
Might be mixed judgment. Might be mixed judgment.
Good, excellent. But we'll talk about first views, isn't it?
Yeah, yeah.
Three people who can't see me.
did you cover it?
There is.
I really like it.
That's fine. We can.
Yeah.
Everyone wants to do it. So. it's fine. That's easy to. And then I'll start amending the other one.
Wearing armour suffered serious injuries during boundary match when sword entered his fiancée. Let's see how far. And that's the way to go. That's the way to go. I mean, that really is reenacting well. Kills them. I've seen something like that. Hey, come on.
Oh, that's showing now.
Or did we do something?
This is a new
Court rises able.
Ladies and gentlemen, I'm grateful for the time
Yes.
that's been afforded. Having had the opportunity to take some instructions, there were some observations that the BBC wished me to make to seek to assist.
Yes.
And obviously the court has the document we prepared for the permission application.
Yes.
As my lady helpfully identified in the opening of the appeal, there is obviously an important balance to be struck between delineating the scope of any power to disclose documents within the broader context of a positive development of transparency within the family justice system. Obviously, I'm particularly assisted by having instructions from Ms Berg, who's been a particularly active and
Well, her work has been invaluable.
indeed a relatively small number of journalists who have been particularly engaged over a number of years.
Yes.
And who are encouraged by the family justice system's commitment to transparency, the implementation of the pilot, and then the subsequent reforms that have been implemented. So the BBC, I hope, understandably from the court's perspective, are keen to ensure that insofar as the court deems it appropriate in the circumstances of this case to make observations on the application of DRING in the context of family proceedings, that broader positive trajectory and context is acknowledged and recognised. We're grateful for that observation. The second observation that I'd make, which is a general one, which goes arguably to all aspects of the various balancing exercises that might have arisen, is, again, my lady's observation of understanding why the application was brought, and a general acknowledgement that the particular circumstances of this case, which in light of the reporting restriction order I won't delve into in any detail, but are plainly before this court, both in relation to the underlying matters, the court's general awareness and, of course, Mrs Justice Lieven's judgment, that serious and important public interest and journalistic purpose are both plainly apparent and I think rightly acknowledged, notwithstanding the case that is brought to resist the application and to pursue this appeal. And in a sense that that opens up into a broader but short and very respectfully advanced submission in relation to some of the language that is occasionally applied in terms that can sometimes arise based on the case law of fishing expeditions, archaeological digs and so on. The reality is that in all cases, those who are seeking to pursue a proper journalistic purpose from the outside have to seek to calibrate their requests and applications in a way that seeks to be forensic and focused. And in this case, the BBC certainly aspires to focus its application appropriately on the issues, the critical issues that it identified. So I hope in terms of context that assists. In terms of the court's understandable wish, and I very much understand having not only granted permission but also sitting as a very experienced court and having my lady sitting on the Constitution, we well understand why the court, in seeking to assist practitioners and judges to apply the green principles, seeks to make observations arising from this case. And of course, equally, the observation that that have been made in the submission that I advanced in the request was partly on anticipating that the practical difficulties of publishing Mrs Justice Lieven's judgment may be insurmountable. We plainly do not in any sense seek to dissuade the court from an appropriate version of that judgment being placed in the public domain, and I well understand that in circumstances where the court may have anxieties about aspects of that reasoning, why that would then also encourage the court to seek to address it.
But it sort of feels counter to our transparency and open justice agenda if we then don't publish the judgment which is going to be overturned on appeal, on whichever ground ultimately that is done.
Yes,
It would felt very uncomfortable.
That depends partly on the scope of the manner in which the court seeks to address that. If that scope is more expansive, that necessitates a greater degree of public understanding as to the terms of the original decision. And I fully accept that if the court is minded to deal with matters more generally and in more detail, that the two are interconnected. I suspect from the parties, and certainly the BBC would never wish to stand in the way of any aspect of additional publication. It may have been a concession based on an appreciation that process may be challenging, and indeed I know that Learned Friend may well address the court on the scope that it may go beyond anonymity and that there may be matters that need to be taken with a more of a redaction style approach, given the nature of the issues, if the court is minded to seek to protect the identities of those involved as far as it can in the context of that publication. The court will obviously be assisted now by sight of material that obviously wasn't before the court at the permission stage, but was certainly provided to Mrs Justice Lieven ahead of the hearing in December and her decision in January, which sets out the background, and obviously the BBC also have that some limited access to those documents that the court identified. In relation to the court's observations in relation to the application of DREAM to this case, I'm invited to seek to address the court on the fact that there is obviously a particularly unusual aspect of this.
It is unfortunate you didn't do a skeleton argument, isn't it?
Well, my lady, as I said, we sought to address the court through the framework of the consent order, and we had understood that that was a matter that the court was satisfied to proceed without the skeleton argument on the basis of the application.
All right. So, all right. Is this a new point? What, the point you're making is?
No, not at all.
All right.
The reality is that it is simply the transmission that every decision is one that is on its facts, and in this case, unlike many cases that my lady will obviously be familiar with, where there is a difference in the dynamic of the interaction between what happens prior to the issue of proceedings and the degree to which that falls to be considered within the court process. I think that's the narrow point, rather than seeking to address and expand the scope of matters. And then, my ladies and my lord, the matters that we placed before the court in responding to the court's query, those submissions are included within a note which is at page 112 of the core bylaw. And in terms of those submissions, obviously the court will likely focus substantially on the decision of the Supreme Court in Dring. That appears within the authorities bundle at page 337. And my ladies and my lord have the central component of that decision at 354 at paragraphs 42 and 43.
Mr Barnes, do you think you could just keep your voice up? You're battling against the fan.
Of course, apologies. 42 and 43 are at page 354 in the authorities. And so again, in the course of the note prepared for the commission hearing, at paragraphs 4, B and C, we sought to assist in relation to the identification of the two critical paragraphs, focus on the principal purposes behind the open justice principle. That obviously acknowledges it's not a closed list, that there may be other categories. And Mrs Justice Lieven's conceptualisation of the second principal purpose, the enabling of the public to understand how the justice system works.
Where do we see that in her judgment?
Well, the judge noted that the matter in her view fell squarely within paragraph 43 of Dring. She conceptualises that as part of a broader family justice system, including the local authorities who bring applications.
Yeah.
I know
that's quite a novel conceptual approach, isn't it? I haven't seen that ever before.
And I well understand why, in circumstances where that is the hook that Mrs Justice Lieven applied, that where the court may take the view that there is a particularly sharp delineation in this case that applies, that may undermine aspects of that reasoning. But in relation to how the judge approached matters, certainly there was an identification of that authority and the manner in which she conceptualised that as falling within paragraph 43. But
yeah, I mean, to my mind, there's a paradox in the judge's judgment. She says, here's an area of private fostering that no one ever looks at. So we must have some open justice about a case that's not to do with that. That seems completely topsy-turvy. The point about open justice, as I understood it, is in paragraphs 42 and 43 of Dring, which is to do with the workings of the justice system, not to do with the operation of things that happen outside the justice system, but could, but didn't, get scrutinised.
And suppose that falls back on whether that list is a wholly closed one, but I don't
Yeah.
seek to advance an entirely novel principle in circumstances where the BBC is ultimately...
Well, there's that tempting allusion to the possibility of other purposes of the open justice system.
A delicate foot retained in to see where matters
Yeah.
lead. I suppose that the reality may reflect some of the language that is used that may not, in referring to the family justice system, that may encompass in layman's terms, but perhaps not necessarily arising in the same way in my Lord's observations as to drill of the dynamic interaction between those, such as the local authority, that bring proceedings and are the trigger for court action. And so I think in that we obviously sought to assist that if that second principal purpose includes enabling the public to understand how the justice system works and why decisions are taken, whether, following Mrs Justice Lieven's line, that might encapsulate decisions that feed into proceedings. Obviously, at the point at which the determination was made and the permission was granted, the court didn't have the additional documents that are now before the bundle, which I understand that may be unusual in that, in many cases, the actions that occur prior to the issue of proceedings are central to an establishment of threshold and may be central to the court's factual inquiry to justify the making of orders at the ultimate conclusion of the proceedings. And again, I accept that whilst there are references within the documents that have now been disclosed, and there are certain observations that are made, that may not amount to the value judgment or finding that had certainly been implied. And I think in the course of submissions, Mrs Justice Lieven indicated that there may have been value judgments that were made by the judge. There are obviously limited references to some of the experiences.
There's very little there.
But it plainly wasn't a central inquiry and wasn't the basis we understand it. That
It wasn't the basis of the care proceedings, no. It wasn't the basis of the threshold.
Yes, in a sense, it's the unusual delineation that the trigger of the conclusion of that placement wasn't necessarily one that fell as part of the local authority's review. And that may be an unusual aspect of this decision which marks that apart. And I think that's where, again, without wishing to introduce new arguments or expand the scope, there is an unusual aspect potentially of this decision as to how sharply that delineation arises. And insofar as the court might then consider that there is scope to bring the exercise within the paragraphs of drink, plainly then the court goes on to consider the balance as between any proper journalistic purpose and public interest that arises, balancing that with the interests of the particular children and other parties who are affected, a task which, respectively, Mrs Justice Lieven undertook in a conventional manner and in relation to publication trod a very familiar and well-established path. And I hope that in the BBC reflecting on its broader desire to sustain the decision on the basis of its continued reflection, based partly on the documents disclosed and obviously on the manner in which the appeal has been presented, that the concession was certainly an attempt to be focused in relation to that element of the exercise that was being undertaken by the court, which arises if my ladies and my lord consider that there is scope to bring matters within those broader dreaming principles. I think, my lady and my lords, the only final observation to make is that we are obviously grateful to the court for the manner in which the hearing was reduced in its time estimate to reflect the broad consensus that had been arrived at between the parties, and part of the effort that the BBC made in seeking to identify in advance that it was not seeking to continue to oppose the appeal, was a desire to address matters in a proportionate fashion. But I hope not unhelpfully in the additional submissions that I've been instructed to make this morning. I'm very happy to assist if I can in any other matter.
No, thank you.
No, thank you very much indeed, Mr Barnes. Very helpful. And certainly we recognise the context of this case, and certainly, again, it's absolutely right to say that the extent of the limits, the application of the limits of the principle will always turn on the facts of each specific case. No question about that. Ms Brereton, Mr Patterson, Mr Lafazanides, would anything you'd like to add?
No, I don't think so. Everything that we needed to say on ground one is encompassed in our skeleton argument. And Lord Justice Warby said it was a novel trespassing outside of the dring. It was unheard of, actually, to widen the ambit of the parameters of open justice in the way that Mrs Justice Lieven did, because, as we said, and it's in paragraph 49, that's a floodgates argument. It potentially does open the floodgates, but I think you have all of that in written form in our submissions. But we say that that's unheard of, and the walls of open justice and the open justice principle were breached by virtue of the judgment and her decision. But I don't, unless you wish me to, which I doubt, I don't intend to travel through the document. The only other thing I would flag up, and I did a whistle-stop tour, my phrase, rather than anyone else's, at the permission to appeal hearing of how the BBC application evolved or morphed from its initial looking at what the court did, what the decisions made, to ultimately the monitoring of the effectiveness of private fostering arrangements. I think that's quite an important backdrop in terms of the dring principles and those walls being breached. By the time it got to the 6th of December, the dring principles were, I would suggest, no longer there. They'd certainly been blurred on the way there, but they were gone by the time Mrs Justice Lieven dealt with the case. So unless I can assist you any further on that point or those points, I don't intend to address you on anything wider.
No, thank you very much indeed. Mr Patterson.
Nothing too much from me that hasn't already been written in my local authority skeleton argument's been put forward. I don't suppose anything else with you.
Thank you very much indeed. Mr Lafazanides.
My ladies, my lord, the carer is Ed Arden with the Guardian in respect of this.
Sorry, I think we are being fanned out.
Terrible noise from the fans.
I apologise, I shall raise my voice.
Don't worry.
The carer is, as you're aware, Ed Arden with the Guardian on the grounds of this appeal. Is there anything specific I can assist my ladies and my lord with?
No. Do we want to talk about the, just to tell you where we propose to go, do sit down, is that we have obviously thought about this case quite carefully before coming into court. We hope to be in a position to give judgment this morning, or rather this afternoon at noon, 12 o'clock. We will, at the same time as giving our oral judgment, which we will do orally in the interests of open justice, we will also have a written judgment that we can hand down immediately afterwards, so you don't need to get a transcript or wait for any of that. Would you like to deal with the detail of the order now?
Yes.
Or would you like to deal with that after we've given judgment?
Well, we're in your ladyship's hands, because obviously if that's the aim and the pathway that you are now going to pursue, perhaps judgment first and then we can address you on the order. Just so
Are there any obvious objections? Mr Barnes, you probably haven't had a chance to think about the order. Anything in particular that leaps out as you as being objectionable in our proposals?
Nothing, save that, and I think Mr Barnes just alluded to it because I mentioned it as we were coming back in, because obviously he'd been with his clients, that in terms of anonymisation, the boundaries of anonymisation might have to creep outside of what we would traditionally call anonymisation, because there are some factual elements which, if published...
There's jigsaw
exactly.
Identification.
But I think we're
I'm not giving too much away in terms of my lady and my lord's discussions with me, that it's not a straightforward exercise.
Exactly what I said, my lady.
And it will need to be done extremely carefully.
Yes, agreed.
So we agree with that. I think jigsaw identification will be a real issue here.
Yes, agreed.
But if you want to come up with a time period for the anonymisation exercise to be completed by, that will be helpful. 14 days, for example, something like that.
Yes.
But you know more about your own commitments than we do, but come up with some sort of a proposal.
We will do.
And if anybody is tapping away with a revised order on the back of what I said...
My junior may be, as we're speaking, but I don't want to say that she is. She's not.
Good. Well, we always like to hear from the second row. So
My
perhaps...
lady, I am.
Good. Perhaps we can...
Can I just say something about the anonymity
Yes,
Yeah.
please, yes.
The point about the reporting restriction order is, as my lady said, that the aim and intention and the agreed position doesn't seem to have been reflected in the draft that we got. Somehow there had been some misunderstanding. So what we've got doesn't mirror.
It doesn't, and I must take some responsibility for that because it was sent in on the basis it would mirror the exact terms of the 6th of March. I think, to be fair to my solicitor, she was away, and so we've looked at it now, my junior and I, and my junior in particular, and we recognise that that should have been really done with a bit more care. So we apologise to the court for that.
It's fine, as long as we understand what the problem is.
Yes, we've got there,
Don't
and
think
thank
it's
you
too
very
difficult
much.
to put it right.
No.
So if somebody wants to email my clerk a revised draft order by sort of say 5 to 12, then we can have a look at that before we come in, and we'll try and be a little more true to my own deadline. I think we were 5 minutes late last time. I'll try and do better next time. So let's say 12 o'clock. We'll keep in touch if that changes.
Thank you very much.
Thank you very much.
Let's speak to just into. Sorry, just
Thank you. Laptop. Sheet, I'll just hand these things in.
Yeah, of course.
It's 2 hours. All the days.
14. Okay, well let's put that in tomorrow. 14 for the first drop, and then 14 for the rest of us to eyelash. Frankly, make sure that it's okay. Okay, good.
I was going to say coffee.
Don't worry about it. So.
Something cold.
Yes.
Do you want? Try this. What we can.
It's all right. I'm all
Once
right.
you go back in,
now.
I'll
Yeah.
plug it in down here.
And you're doing so 14 plus 14. Yeah.
Sorry, did anyone need the Lady Chief Justice's?
Yes, please. I can't see email address.
Thank you.
You have to have a poster on it.
You can add it to that list.
Well, no, I know.
Thank you.
Well, I've got it on print.
And then so, if we have 2 weeks for the day, 2 weeks for the yes. 3 days back to them, 5 to the court. If everyone has the opportunity to get the difference, it's only if another party raised an organisation, then I'll give them a copy of it.
Okay. Yeah. It's 2 days, I think.
Yeah.
Is what I have to tell
Yeah,
you.
I'm fine. Yeah.
She might do it for 2 days.
Yeah.
That's 28 days. There's no What was Mr. Yeah. And I think if Lady Chief Justice asks, it's still kind of okay.
so much.
Here's a fun picture of me and my sister.
When did you go home?
Yeah, well, it's just a flash. Two relatives.
So upset.
But I know that. There's me looking like an idiot right now. Because we're a cool family.
Yeah, I could see it.
Yes, please. Thanks, Dan. Thank you. I saw it at the time, yeah. Karen, we haven't redacted the skeleton for this hearing, so we will do that and send it to you after.
Is that all right?
if that's
Thank you.
It might take us a couple of days if that's all right.
Pardon?
It might take us a couple of days if that's all
No, it's fine. We just asked. I was just chatting to my colleagues about the judgment and whether we publish it now anyway, because it's hard to tell the story about what the court of appeal overturns when you don't have a judgment originally. If you don't have the judgment on appeal.
Yeah.
So by the sounds of it, we may be waiting some time for that to happen anyway, given the extent of anonymisation that's going to have to take place anyway. So, but yes, that's fine. Thank you.
Save Callum a job. Can I get it sent to me as well? Thank you. That's
could I potentially take your email now?
Yeah.
Just in the event that, because I'm conscious you guys are far busier than me, so I'll, and things people get snowed under, so I'll drop you a line. No, I'm from PA. I'm one of the people that loiter around here in the corridors all day and just wait to see what happens.
Can I check a realistic timeline of when the judgment, not this judgment, Wolfson's judgment, would be?
We just agreed on timescales for that.
Okay, fine. Because obviously 2 weeks, I know Local Price said 2 weeks, but that would be for first drafts, not necessarily the one that's published. So it'd be longer than 2 weeks.
So I think at the moment we're looking at just over 4 weeks.
For a public judgment.
For the previous judgment to be provided.
Okay.
That's subject to the court's views on that.
All right, thank you.
No worries. Then I'm just going to send it. No, it's fine, don't worry. Thank you. No, I have no doubt in your time, Benny.
Do you know what the proceeding is?
I don't know.
Is this your vote? And your vote in Local Price? And that's how I tell you this. But if BBC do it, and I've told them they can't get a source from that.
Yeah. You just have to go.
Can you do that? Double check so you can see. Yeah, I will be sending to the Thanks so much, Bella. Yeah, can you just write it on there for me? Thank you.
Do you have a pen for it? Sorry. Cheers.
Thanks so much.
I got yours, yes, sorry, I was meant to be running back.
No, that's fine.
Yes, I've got it. You've got the two, thank you.
Excuse me.
No, I'm just checking it.
I am
Are you doing it?
typing as quickly as I can.
Let's see.
Yeah.
I'm sure there'll be a bit more to that.
We'll see.
We've still got 5 minutes.
Yeah, thanks, George. the date of
What's the date of it? It was the 15th of January, the notice. But didn't you just say the appeal was allowed?
Do we need to specify it? Because she said she didn't tell us what ground she.
Whereas in nursery they're all sleeping, so it's I think just she just said the appeal was allowed.
Yeah, it's just the first paragraph.
Yeah, exactly.
Great.
Setting as the order of Mrs Justice Lieven.
Save that.
An electric car.
Yeah, it was a paragraph on discussed. It's in there.
Yeah,
Save
yeah,
that,
yeah.
save that the judgment should be
Yeah,
published.
and so I've dealt with that in the judgment publishing.
You put it in
paragraph.
two
Yeah.
paragraphs, I think.
Yeah.
I think we should say that. Rather than mentioning that we should say reporting instructions or small point, just for clarity. So paragraph 3. Mirroring
What-
the
Mirroring the.
reporting instructions or the dated
Great.
6 of March.
Yeah.
Yeah. I think that's it.
Okay.
Okay.
Yeah, I've done all of those.
It's an undertaking, isn't it?
Just so you know, and I have your I've just said the appeal was allowed, so we've just added that in. Changed interim order to say reporting restrictions already dated. Just mentioned.
Have you seen Chris's response? Have you seen Chris's response?
No, because Chris has sent a response apparently, so.
You just have to essentially wear a big towel around your shoulders. It's just not good.
She's looking at that.
Oh gosh, this is
You look like Batman as well, which would be fantastic. Glide around. Rachel, do you need a charger?
No, do you know what? I think it's angry now.
No worries.
I literally just went with the notes that the lady said, so.
I think if
Do
you
a lot of quite a few overthrow cases in these. The months go through.
Would you mind? And then adding the electric.
None of the dogs. None of the dogs.
Yeah, I've just sent a response to Chris. I've just sent a response to Chris saying that if he wants these reserves, he's going to have to raise it with respect to what she said. She said it's best for him to raise.
What recitals is he after?
He's suggested
You need to send it. It's 5 to 5. Yeah.
go on. I suppose it's an undertaking, and so it doesn't have to be Joyce wants to think and she's in the building line with
Yeah.
Can you say
I do see the point. But
And then I just think 2. Just on
Yeah, we don't really not do it. When I was younger, when I was younger, when I was paralegal, I had a law firm that solely represented full respondents. So yeah, that's
Can I assist?
yeah, no, yeah. Just getting very good at standing up and sitting down at the same time as you're already on your way down. Yeah.
Sagely.
Yeah, nothing further from me. They're the clients we want. So send them our way.
Yeah, I mean, I've got a hand.
My fears were slightly low, but
Did I send the wrong one?
Yeah, I've sent, I think I've sent
it's tenuous at best. We can vote with
I always got phone mask ones, you know, where they're going through that big book of phone.
I'm not sure what I'm learning.
Going to the mags for like doing it like one of those, like a full day, like the magistrate just to chill. That's quite juicy.
Tell you what I did.
some interesting.
Yeah.
The best time I was when I was on jury duty. So jury duty for that. And that was really good meeting all I think I've got to check she's doing exactly 26. Which is page 70.
It's even the speeding offences mentioned.
This was
It's good when they weren't sitting around the table. All local mates, but
It's a famous judge that
what I should have done was I apologise.
Thank you.
The gateway signs that say 30 are there when you come into the meeting. And once you're in the meeting, even if you do go into the meeting,
don't go back.
Sorry,
They could run on the next one. Can you just
thank you for letting us know.
10 minutes? Okay.
Yeah, so that's why I've got contacts. I've got the street. With the radar gun.
Oh no, or even worse. I put that down to bad luck. It's a machine.
I'll take my wig back off and go outside here. Thank you. Another 10 minutes.
Right, I'm still going to keep.
As you can see from the picture, the colour substitute with no one else in the room.
Did you do your own mitigation?
They actually very lenient again.
Happened to me. My mum doesn't let me.
Because that's part of the speed limit.
Yeah. Yeah.
So they did.
Good result.
Although they didn't.
She stayed in town.
Because if you get and points totting up,
Yeah.
the points reset that.
Yeah. Oh, so you,
This
because
was
of
a
such a.
that didn't reset the point, unfortunately. So, I took it
take the
Yeah.
important,
Yeah. How was it giving submissions on your own behalf rather than on behalf of the client? Was it completely different?
It's strange,
Yeah.
but I think that I had a bit of a quick and back and forth with the magistrates because I said, I know, you know, given my oath and I know what it entails and we've seen it all.
Yeah. Some magistrates might go harder than ones with certain members of the bar.
That's possible, but I mean, I genuinely, I was kind of the last window of my partner's pregnancy and she doesn't drive, so you know, there was quite a lot of
A lot of mitigation, yeah.
She's past her text and she's on the road as well.
There we go, yeah.
4 6 months.
Yeah.
But you're right, there's every possibility that they're throwing because we should have
Or just some member of the bar's been rude to them before, haven't they? I often do crosses with previous magistrates.
people on performers in person.
Yeah. Yeah.
So I think we're comfortable in the crisis situation and making it people's names and addresses.
Yeah, good luck spelling your name, that'd be fine.
one time that you didn't spell it out for us. Just George.
It's just, I have had magistrates ask me things that I really don't know why I want precious. We just have missed the head and corrected Yes.
No advocacy needed from your end.
No, that's actually not much to say.
You call them this to because it's on
We need to process a home. It was all she switched. So it was an interim period. Taking his children in. And then he just shot himself in the foot. He said, well, if my contacts are restricted, I won't have people.
just go, if it's not one thing, then do it. So.
That's exactly what's not
More than
more so we don't have to rely on contacts unless it's what we've got. So we're completely shunted up the ladder as well.
Sometimes magistrates get a bit funny about it. You're essentially saying, you're not intelligent enough to be able to deal with this.
So you should say, we had to do the kick charge. It's a bit on that account. And me as well, and then so if this one's going up, do you know she's been recorded about really in front of this particular circuit. We are looking at something for sure. And we had to make this action. This is a high court decision.
No offence.
We focused on the 8th of the hearing. We need 15 days of court. We know we're on others. Well, that's a worse case. Siblings and allegations of ignominy. It's a really wide range of experts. Yeah. There's children, subject children, to non-subject children, hence non-subject children being dragged into things, and it's very complicated.
That's a
Timing, I like that.
Well, it wasn't meeting,
Was
it's
it
now
meeting?
got
No, it's
Mrs
local.
Justice about
No,
an interesting experience last weekend. I did the MPP services. She was on the she was very professional. He was genius. She was first. She was like,
so just
and she took focus of it. She became focus very pleased. Burned into my brain.
It's the worst nightmare.
She was the most fearsome judge I've ever been in front of. And you know, was against like, I'm just trying to leave.
Did it ever get addressed by it?
The beauty of her. Yeah, from there.
It's so funny, you spend your lifetime creating this reputation and just
Disappears in a minute. Stupid.
No, no, it's like, leave school. So just that,
Then it became even more important. It's a good thing to have somebody like that as your liaison judge to put the teeth on and, you know, put the fear into you. You literally do it.
Was it till...
at the moment it's until the appeals determined.
Ooh.
It's just been inclined to just turned up with a bottle. Followed everything I needed to do. And then we just sat there and went through the these were red ones.
Yes.
As to what
My
this
son's
is.
at this private playing time. I was with my and I do know what I'm doing.
Just for context, Judge Garth is the judge who says still hasn't. We've got 16 seconds of your cross-examination left according to the Prime Minister.
Did you position statement to make?
have you been going for at length about the party?
He's a decided court. Norwich court.
Yeah. It's
I got like Mrs Justice. Usually I'm on the other side. Yeah, he does.
He does.
He knows what representing him, sort of plays up to it.
Once you've seen
There was one time we sat in Luton with Warby when he was he was giving judgment and there was a pigeon that stopped and said
I don't have
I had the pleasure of sitting next to him at the table at his Luton Parish Justice Conference. I haven't been to those couples, so he's been going back a couple of years, but it's just really
Busy.
really quite
told them every day. Told me that he had a telephone after and how many people.
TO, that was, I think it's something which is 2029.
I do get the lemon. There are a lot of so right at the bottom you've got position.
Just hash out.
Do they go well? Okay, the campaign's going to believe in analysis and
he's doing really good, I suppose, here. It seemed very reluctant with the numbers and change.
I would say, isn't that hard to live with for 60 years? Isn't it?
Should we go back to
I quite like Swedish. Middle of the term I proposed 20 years. The entire correct time spent on art.
Which is a bit of a shame, because I think it's been very
Given your rate with the core practical purposes, like do so short term, you never even need to die for it.
wouldn't have been any
Like cold.
more romantic for
additional bit of power.
but you know, and so this is why we've been chatting. But I feel that too as well.
No, I got you.
So not I got was just saying.
Thank you. We are ready to give what will be a judgment of the court. The judgment will be published under the title In Re HMP. As indicated earlier, written copies of the judgment will be available immediately at the conclusion of the oral judgment. We will deal with the terms of the order at the end of the hearing. Introduction. This appeal is about access to the court file under the principle of open justice, as identified in DRING on behalf of the Asbestos Victim Support Groups Forum UK against Cape Intermediate Holdings Limited, Media Lawyers Association intervening. Citation, DRING. The purpose of this short judgment is to address a matter of general importance, namely to emphasise the limits of the open justice principle, specifically in the context of care proceedings under the Children Act 1989, the CA. Open justice is a fundamental constitutional principle. The underlying rationale is the need to allow the media and the public access to information about the work done in courts and tribunals, so that not only individual decisions, but also the operation of the courts and tribunals more generally can be subjected to appropriate scrutiny. Allowing such scrutiny serves the public interest by keeping a check on the way in which judges behave, enabling the public to understand how cases are decided, and ensuring public confidence in the system of public justice. To serve these ends, procedural rules, in particular CPR Part 5.4c and FPR Rule 12.73 PD 12G, make provision for non-party access to court documents or communications between the court and a party or another person. The open justice principle may also require that media or public access be given to a wider range of documents than those prescribed by the rules, unless prohibited by the rules. The appeal is brought against an order made in the Family Division of the High Court on the 20th of January 2025, following care proceedings under the CA concerning 2 children. The order granted an application by the BBC for access to documents in the proceedings, the partial variation of the reporting restrictions imposed by Section 12 of the Administration of Justice Act 1960, so as to permit reporting of specified kinds of information drawn from those documents. The order was made on the basis that the open justice principles, as identified in Dring, applied, that the issues into which the BBC was looking were matters of public interest, and that, conducting the familiar balancing process identified in INRI S. a Child, Identification Restrictions on Publication, the rights of the media and the public to freedom of expression outweighed the privacy rights of the children. The appeal is brought by the guardian of the children, acting as their litigation friend. There are in substance 3 grounds of appeal, namely, 1, that the application was not made for any purpose connected with the open justice principle. Accordingly, Dring was not engaged, and there was no balancing process to conduct. Alternatively, 2, that the balancing process which the judge, Mrs Justice Lieven, undertook was flawed because it gave undue weight to the fact that certain information relating to the children was already in the public domain. And 3, that the judge placed insufficient weight to the rights of the children. The appeal is supported by the individual in whose care the children have been placed by the court, the second carer. The local authority also supports the appeal. The appeal was originally resisted by the BBC. The BBC has, however, now consented to an order that the appeal be allowed and that the judge's order be set aside on the 3rd ground. The BBC has stated its position as follows, quote, "The decision to offer to agree to the setting aside of Lieven J's order by consent has been reached following careful consideration of our duty of care under the BBC's editorial guidelines in relation to the 2 children. The guidelines require us to take due care over the physical and emotional welfare and the dignity of under 18s who are involved in our editorial content, and, having considered the submissions, and particularly those of the second carer, it is our view that maintaining our opposition to the appeal would cause them undue harm. We agree that the appeal must be allowed, but on a basis different to that advanced by the BBC. Fundamentally and importantly, the appeal must succeed on the open justice ground, the 1st ground. In summary, whilst the issues which the BBC wished to investigate are matters of legitimate public interest, those issues arise separately and distinctly from the issues that arose in the proceedings. The purposes behind the BBC's application were not connected with the open justice principle, and the application should not have been entertained under the auspices of that principle. The facts. We have used generic terms to refer to the parties other than the BBC because that is necessary to ensure that the appeal is not rendered futile by disclosure of the very kind that is in issue. For that reason, there is in place a reporting restriction order. For the same reason, the account of the background must be in broad and general terms. The background in brief is this. In late 2021, the children's mother arranged for them to be looked after by a friend of hers, the first carer, under an arrangement which all parties agree was, as a matter of law, a, quote, private fostering arrangement, unquote, within the meaning of Section 66 of the CA. After about 4 months, the first carer gave the local authority notice that she could no longer look after the children, whom she left at school with their belongings. The local authority promptly initiated care proceedings in the family court. On the 1st of April 2022, an interim care order was made. The threshold criteria did not rely on the time spent by the children with the first carer. Shortly afterwards, the children were placed with a second carer. The care proceedings came to an end in August 2023 when an order was made confirming the placement of the children with the second carer under the supervision of a different local authority. Events in 2022 and 2023 in which the children were not involved prompted two respected BBC journalists to take an interest in the way in which the children had been cared for by the first carer and the role of the local authority in respect of those arrangements. The application. On the 4th of October 2024, the journalists, or the BBC on their behalves, applied to the Family Court for access to various documents relating to the care proceedings and permission to report the contents of those documents, subject to certain limitations and restrictions, which were designed to protect, as far as possible, the interests and rights of the children. At this stage, the BBC knew little about the proceedings and the involvement of the local authority in the lives of the children. The BBC believed, and the basis of its application was, that the children had been placed by the local authority with the first carer following an assessment by the local authority. The purpose of the application, as then stated, was to understand how the children came to be placed with the first carer by the local authority as part of the BBC's role as watchdog generally, and specifically in relation to the operation of the family courts. The application was transferred to the Family Division of the High Court and came before the judge. The full hearing was fixed for the 6th of December 2024. By this stage, the BBC had learned of the true factual position. The decision to place the children with the first carer had been one taken by the mother privately and without the local authority's involvement. It was a private fostering arrangement which had ended prior to the proceedings commencing. Upon appreciating these matters, the BBC had amended its application and shifted the grounds on which the application was based, focusing now on reporting on private fostering arrangements generally and the monitoring of the same. In its skeleton argument in support of the amended application, the BBC put its case as follows, quote, focus of the application. The BBC makes clear that its central focus is on investigating, with a view to reporting on 1, the circumstances in which the children came to be cared for by the first carer for a period of some 4 months, the degree to which the local authority fulfilled its fundamental safeguarding role, and 3, understanding the children's experiences in the first carer's care. It is that clear focus that forms the basis of its amended application. The judge heard argument from counsel on behalf of the BBC, the local authority, the second carer and the guardian. On the 15th of January 2025, she gave a reserved judgment by which she upheld the application and made the order. The judgment below. The judge's reasoning may be summarised as follows. 1. To resolve the application, the court had to apply a balance between the Article 8 rights of the children and the second carer, and possibly other third parties, and the Article 10 rights of the press to report. The outcome would depend upon a detailed scrutiny of the rights engaged with what the judge called, quote, close regard, unquote, to the rights of the children. 2. Although the disclosure sought would amount to an interference with the children's privacy rights, it would not add a great deal to what the BBC already knew and was free to publish in any event. Granting the BBC access to further information and the freedom to report upon it would not add materially to the harm that the children would suffer. 3. There was also a real public interest in, as the judge put it, quote, reporting on this case and the circumstances which led to the children being in the first carer's care, unquote, and certain other issues including, quote, interagency working and school oversight of children, unquote. 4. To grant the orders sought would serve the interests of transparency in what she referred to as, quote, the family justice system, unquote, and in accordance with the principles identified in Dring. 5. In these circumstances, the Article 8/10 balance tilted, quote, quite clearly in favour of allowing reporting, unquote. As will be apparent, a critical factor in the judge's decision was the weight to be placed on the public interest in transparency and certain specific issues. The key features of her reasoning on that topic were as follows, quote, and we set out all of paragraph 17 and all of paragraph 51, all of paragraph 52, and the final sentence of paragraph 54 of the judgment below. Discussion. As confirmed by the Supreme Court in Dring, quote, and we set out all of paragraphs 41, 42 and 43 of Dring. The court in Dring thus identified two main purposes of the open justice principle, namely, 1, to enable public scrutiny of the way in which the courts decide cases, so as to provide public accountability and secure public confidence, and 2, to enable public understanding of the justice system. Whilst the court recognised that its identification of these purposes might not be exhaustive, the core aim is to ensure appropriate transparency for the work of the courts and tribunals and the judges who sit in them. As is apparent from decisions such as Newman and against Southampton City Council at paragraphs 48 and 49, it is important to understand and respect the limits of the open justice principle in this context. Court files may contain a great deal of information that is commercially sensitive or confidential, or, as in this case, personal and private. The open justice principle does not extend to affording third parties access to such information for reasons unconnected with examining the work of the courts and tribunals and the judges who sit in them. The Supreme Court in Dring made clear that a non-party has no right of access to the court file. The court's permission is required. It is incumbent on the person seeking access to documents under the open justice principle to explain, 1, why they seek access, and 2, quote, how granting him access would advance the open justice principle, end quote, see paragraph 45. In this case, the BBC's amended explanation explained why it wanted access to the file, but said nothing about how this would advance open justice. The limits that we have identified were overlooked, and the judge's approach to the application of the open justice principle was wrong in law. The objective of the BBC, whilst undoubtedly part of a legitimate journalistic investigation, was neither to scrutinise the way in which courts decide cases, nor to enable the public to understand how the justice system works and decisions are made. It was not in any way designed to throw light on the workings of the family courts and their judges. The central error into which the judge fell was to define the family justice system as encompassing not only the work of the courts, but also, independently of the courts, the operations of local authorities and other state agencies working with children, and then to apply the principles identified in Dring to the entire family justice system, as so defined. That is not what Dring is about. The application of open justice principles is confined to the system of justice in the narrow sense. Disclosure for one of the purposes identified in Dring may, incidentally, facilitate scrutiny of decision-making by local authorities and other public bodies, but enabling such scrutiny is not itself a purpose which requires or justifies disclosure under the open justice principle. Each case will, of course, turn on its own facts, and there may be cases where the manner in which a local authority has discharged its safeguarding functions is subject to examination in care proceedings. Disclosure under the open justice principle may then be justified, but as set out above, that is not this case. Nor was it correct to state, at least by the time of the hearing in December 2024, that the BBC wanted to report on the proceedings themselves. the proceedings were not relevant to the issues which the BBC wished to investigate and report on. On the BBC's own account, its application was focused on matters other than those that had been addressed in the proceedings. As Ms Brereton KC put it, the BBC wished to monitor the effectiveness of private fostering arrangements. Our conclusion on ground 1 is sufficient to dispose of the appeal and makes it unnecessary for us to consider grounds 2 and 3. Conclusion. The BBC was not unreasonable in making its initial application in the context of care proceedings at a time when it believed that the private fostering arrangement had been sanctioned by the local authority. Once it became clear that the local authority was not involved until after that arrangement had come to an end, and that the courts had had no involvement at any stage of the arrangement, the application should have been withdrawn. Access to information about the underlying events, if to be pursued, would have to be sought by alternative routes, such as potentially an application under the Freedom of Information Act 2000. The principles of transparency and open justice are there to allow the workings of the justice system to be understood and examined as appropriate. Nothing in this judgment is intended to undermine the importance of those principles or to hinder or discourage the welcome progress that is being made in the application of those principles across all jurisdictions, including in the family courts. The role of journalists in reporting on care cases is clearly in the public interest. However, care proceedings cannot be regarded as an available source of material for journalistic endeavour that has nothing to do with the aims of the open justice principle. For these reasons, and on this basis, we allow the appeal. Now, we have got some hard copies, but we need to hand those down, immediately asking recipients to make a few immediate corrections.
There's 2, I suppose.
So 2 corrections, if we could hand down, subject to that restriction, please, including the press, just the following corrections for anonymisation purposes and 1 grammatical correction. So this document is being handed down subject to the following amendments, please.
Thank you very much.
Paragraph 6. And please make sure that Ms Bird gets a copy.
Thank you.
So if we could all make the following immediate amendments, which will appear in the electronic version to be published. Paragraph 6, body of the quotation. The second line from the bottom, particularly those of the square brackets, replace that word, please, with the phrase second carer. So that single word, please, to be replaced with the word second carer. Do you all have that? And can I just check with members of the press? You've got that. Thank you very much. Grammatical correction, paragraph 8, first line. Whilst the issues which the BBC page 7, top of the page, please. Quotation from the BBC's application. Please replace in the square brackets the single word so that it reads the first carer. Page 7, top of the page. Do you see the line, children came to be cared for by? The phrase in the square brackets should read the first carer. And the same in the penultimate line of
Give
that
us the
quote.
paragraph number, because mine certainly isn't paginated, Melissa.
Page 7, paragraph 17.
Thank you very much.
You have a quote at the top of the page. It's a quotation from the BBC's amended application. Do you see square brackets appearing twice?
Exactly.
In those square brackets, please could you insert the first carer? Is that okay? Do you see the word that I'm replacing and the word that's being inserted, the two words that are being inserted? And, well, now you're all here, I'll never stop. Paragraph 23. Just for consistency, do you see the sentence beginning, it is incumbent?
Yeah.
Can I just use Roman numerals, not A, B, C? So A becomes Roman numeral 1 and B becomes Roman numeral 2. Got that?
Got that?
And I think that we can live with the masculine gender in the quotations there, because that's what the Supreme Court said in
from
Drake.
Baroness Hale.
I know. So we'll leave that as it stands. Can I just check with my lady and my lord, are there any other corrections? So, yes.
Just one, if I
Yes,
may, and it was spotted by my instructing solicitor,
Thank you.
paragraph 10,
Thank you.
sentence beginning in late 2021,
Yes.
to be looked
Oh, yes.
after.
Thank you very much indeed. Do we all have that, paragraph 21, to be looked after by the first carer?
Yes.
Oh, yes.
Happy with that? The members of the press have that as well. Everybody got that? Thank you, well spotted. So we'll make these alterations for any electronic publication.
Thank you.
So, let us then turn to the order. So I've got some alterations to make.
We've got the order now.
Very much. Right, I'm going to hand over to my lady and my lord to work through the order.
The order, rather than the RRO.
Yes.
Just trying to pick up the right one. All fine down to paragraph 2.
Except in the recital, waiving the requirement of the first respondent. I don't think we need to put BBC, just first respondent.
Yes, thank you.
Yep, sorry.
And maybe it should be for the first respondent to serve a skeleton argument.
Yes, you're right.
In the order itself, paragraph 2, fine so far as it goes, but it should continue, save that paragraph 21, be amended to read as set out in paragraph 3.
Because we're setting the order aside. Save that. No, maybe it doesn't make sense.
I think we're amending the order to provide differently, as in paragraph 3 below.
Yes, you're right.
So some wording to that effect.
So say that paragraph 21 be maintained,
Varied.
but varied as follows. Yep.
Yes.
Otherwise it's set aside.
Yes, exactly.
So save that paragraph 21 be maintained, subject to the following variations. This, Ms Brereton, is why one does not draft in committee. But let's see how we go.
So I think the next point we had was that we were going to take out the words to prevent jigsaw identification,
Yes.
because
It's
they're
more
probably unduly limiting,
Yes.
in the second line of paragraph 3. And in paragraph 4, if you'll give me a moment, I'll find the wording that I was going to suggest.
There shall
There
be.
shall be
Yes.
final anonymity and reporting restrictions order.
Yeah.
In terms similar to those, because they're not quite the same.
No.
I think otherwise.
We were going to give them 14 days.
And that's all built in.
Okay.
So,
Yep.
Yes.
so yep, 15th of July.
Honestly.
Yep, got that?
Now, we got a version of that RRO, which was then, I think, swiftly withdrawn.
Yes, I think, to be fair, my junior thought she was sending you the draft order, and in fact she was sending the draft RRO. So that was
Right.
what happened there. But I think she may have sent the RRO, not quite. The other parties haven't had sight of it currently, but it is in draft form. The RRO, I mean.
Well, I personally, speaking by myself, I don't think it needs to be settled here and now. The points that I had on what I saw
Yes.
were mainly technical, and they can be dealt with in email, but the point of substance was the duration.
We discussed that, in fact, before we came back in, and I think we've landed on the same timing as a transparency order would end in terms of why.
The
Does that
18th
make
birthday
sense?
of the younger child.
Yep.
And you will put the date in
We
and
will.
explain why it's there.
Yes, indeed.
Yeah.
I think the transparency order did the same, and we
Right.
were contemplating mirroring what the
Good, well,
transparency
we're
order.
thinking on the same lines.
Yes. So that was that.
That was it. as
That was
far as
it.
I'm
Thank you,
concerned.
my lord.
Mr Barnes, any observations?
No, only that I think the original draft that was submitted had also included the formal wording of it being bound by the appeal, which obviously has been overtaken by events. But yes, the actual date is included in the order that Mrs Justice Lieven made, which is page 59 of your
Thank you.
bundle that was bounded by.
Well, we'll await the revised draft.
Thank you.
The only other matter was in the reference to the reporting restriction order within the main order on the appeal. I wonder if that might simply refer to the fact that there is a reporting restriction order made in the terms of an order dated the 1st of July, rather than necessarily indicating that it's in the same or similar term.
Yes.
Yeah.
But otherwise,
Thank you.
Thank you. Mr Patterson?
Nothing for me.
Evidenides? Thank you. So if we could have a revised RRO, I'd like to strike while the iron is hot.
Yes.
Could we have it by 2 o'clock?
Yes, of course.
2 o'clock? Yeah. We'll get it done this afternoon. Thank you. I will ensure that an amended, corrected version of the judgment is published.
Thank you.
Thank you very much for everybody's assistance, Mr Barnes. Thank you for turning up and dealing with our concerns. As you see, we found it a very interesting point and an important one, and we hope that it is of assistance in taking forward what, I repeat, we consider to be the really important transparency and open justice work that is going on, and the value that we place on our journalists in carrying out their important work. Thank you very much indeed.
Thank you.
Thank you very much indeed.